discuss about criminal law and introduction to criminal law. As we all know, legal reasoning has 4 branches, and one of the most important branches which we deal in our CLAT exams is criminal law, the law of crimes. It is also called as the law of crimes. I am going to give you a brief introduction as to what is the law of crimes before we get into the detailed study. So let us begin with our introduction. Criminal law is related to, all of us know, we can derive by the name itself that criminal law has been derived, criminal has been derived from the word crime. Crime, what is crime? Crime is an unlawful act or omission which shocks the conscience of the society, in respect of which legal punishment is inflicted on the person who is in default either by acting or omitting the act. Either you are required to perform the act by the society, by the law, and you are not doing it, or you are not supposed to do that particular act when you are living in the society and you are doing it. So when you are at default, then it is said that you have incurred a crime and you will get a legal punishment for it. Everything that is declared to be crime by law made by competent authority is a crime. So anything which is against the law and which is derived by the competent authority that this is the law, and you do not have to go beyond the boundaries of this law, and if you try to do anything which is beyond the powers or the authority of that particular law, it is supposedly said that you have committed a crime, and for every crime there is a punishment under law. A list of such acts declared as crime can be found under IPC. Indian Penal Code Indian Penal Code is one of the acts, one of the major important acts pertaining to our criminal law, which gives us the crime and defines the punishment for that particular crime. What is the purpose of criminal law? Purpose of criminal law is to protect persons and property against intentional violence and harm, and the protection of property against theft, fraud and damages. So crime can be occurred against persons and also against property. Alright, so criminal law has been involved to protect the people against the harm or the violence they can occur because of the other, they can incur because of the other people's criminal activities, and also to protect their properties against any kind of theft, fraud, robbery or damage. So criminal law protects both the person as well as his property, because as per our constitution has given us a right to life, and we will not be able to live a happy life until and unless we are protected by these sort of criminal activities when we are living in the society. Also, the law has given us the right to enjoy our property to the fullest. Again, we will not be able to enjoy our property to the fullest until and unless we have been protected against these criminal activities such as theft, fraud and damage. Types of crimes. Now we need to see that what all types of crimes are there. Crimes against human body and life, okay, harming the human body or trying to harm human life, murder, extortion, these kind of rape, these kind of which inflict injury or harm or stress to our body and life are called crimes against human body and life. Crimes against property, again theft, robbery, damage, trespass, these are all crimes against property. Crimes against public place and order, when you are trying to disturb the public peace and order. Okay, so sedition is one kind of you say it is kind of a speech which you are giving to disturb the public peace and order. So the words you are using will said to be sedition when they are inciting the people to hate the government or to hate the public authorities, and in turn when the people will hate the government and the people will have a feeling of hatred towards the governing authorities, what will happen in turn? That there would be absolute chaos in the society. crimes against religion, when you try to incite people against various religions, you know, you're trying to build up hatred in the name of religion, which in turn gives crimes to rights, you know, religious rights. This is one of a very common thing which our nation has always gone through. Hindu, Muslim, Sikhs, they all, you know, all these, in the name of religion, they incite the innocent people, and which in turn gives birth to rights. In IPC 1860 deals with most of the criminal offences. So how do I know for what crime, what punishment should be given? Who decides it? It is very well mentioned under the Indian Penal Code 1860, which is the act which governs the crimes and their punishments. Elements of crime. First, a person. There is a kind of offence. Criminal law applies to human offenders only, and therefore criminal act has to be done by a person or group of persons. Okay, so a criminal law has to be performed by a human. In order to punish, in order to send someone to the jail, or in order to punish someone, to give someone a death sentence, it should be a person or a group of persons. Okay, I cannot put criminal law on an animal. I cannot send a horse to the jail. So for the main element of criminal law, of crime, is that it has to be a person who is it has to be a human being who is the offender or who has done the criminal act. Second would be mens rea. These are new terms. I will also tell you what is the meaning of mens rea. Mens rea basically means guilty mind. Before we get into the detail of criminal law, let me tell you that for any crime to be proved in the court of law, it is very important to prove that this particular act was done with a guilty motive or a guilty intention. The act was intentionally done knowing the nature of the act. The act was done, that means the person was very well aware of the consequences of the act, and still with a guilty mind, with an intentional mind, he has committed this particular crime. So the mental element of crime, mens rea, which is also known as guilty mind, it is the mental element of crime. This is derived from the Latin maxim which forms the keystone of criminal law. To form a guilty mind, there should be first an intention to commit the criminal act. Second, the knowledge of the effects of the act. As I have already told you, there should be an intention that, okay, I have a guilty intention, I will kill this person. I have an intention because I have, the moment he secured a good job after our college placements, and I could not, so I developed a rivalry with my friend, and I had a intention of rivalry that, okay, I am going to break his leg today. When he gets out of the house, I am going to break his leg. And second should be the knowledge that when I will hit his leg with the hockey stick, the knowledge is that of course his leg will have severe injuries, or probably his leg will break. So I know I have the intention, I have the guilty intention, also I have the knowledge and I know the effects of that particular act. Being aware as to what can happen if a person commits the criminal act. I am very well aware what will be the consequences if I commit a criminal act. Let's discuss a case so it will be easier for you to understand. Jayesh hates his brother Jade. This happened since the day he got a big law firm job, which Jayesh could not. So two brothers, one secured a very big job in a big law firm and the other could not. One day, Jagmohan, feared dacoit, enters their house at night. He holds Jayesh at gunpoint and orders him to go and stab his brother who was fast asleep. So one day, the dacoits get inside their house and tell one brother that go and kill the other brother who was fast asleep. Jayesh, if he kills his brother, then will Jayesh be guilty or not? Jayesh will not be guilty if he kills his brother. He knew the consequences of the act. Also he has a good reason to kill him. Still, why do you think he will not be responsible? Because there was not a guilty intention. He was doing the particular act because he was forced to do it by the dacoits. He did not wanted to hurt Jaydev himself. Answer would be no, he was not. He was made to do it by the dacoits. No intention is equal to no crime. The third element would be actus reus. Having a guilty intent alone is not enough. The actus reus is the final act by the offender or the guilty act which constitutes a crime. So another very important element of criminal law. Okay, now whenever you need to prove a criminal law case, you need to depend on these two elements, mens rea and actus reus. Mens rea was the guilty mind and actus reus is basically the guilty act, the physical act which you have performed. Okay, so having a guilty mind is not enough. I may get out of the house, that today I will get inside my friend's house and because of my rivalry, I am going to stab him. I am going to kill him today. But I do not do it. So can you put me inside the jail because this was my intention that I would kill him. But until and unless I will not perform the act, I will not do it physically, I cannot be blamed to have done a crime. So the keystone to attempt criminal law questions is to understand that whether mens rea and actus reus together have taken place. Only then it would be applicable that it is a crime. Otherwise, if even one of the point is missing, because they both are the keystones, if even one of the point is missing, it will not constitute to a crime. When we talk about criminal law, we need to understand from where has the word criminal being defined? From the word crime. Now what is crime? If I ask you what would crime be, how would you define crime? So any act which is punishable by the state, any offense or any act which is against the public policy of the state and it is punishable by the state, it is generally defined as crime. Why do we need criminal law? What is the need of criminal law in our country? To maintain peace and security. What is the ultimate aim of our state, of our government, of our the functioning bodies of our country? To maintain peace and society, so that all the citizens of our country can live in peace and harmony and they can feel secured while they are living in our nation. So to maintain peace and security is the most important and ultimate aim for the society to flourish and for people to live without a fear of injury to them personally or to their property. So that is why it was very important to introduce criminal laws so that the crime could be administered. The state or the constitution punishes certain acts which are against law. Some acts have been specifically defined in the acts which are concerned with the criminal law, such as IPC, Indian Penal Code, CRPC. All these acts have certainly defined some of the acts, some of the acts which are against the public policy and which are considered as against the law, and these kinds of acts are known as crime or criminal activities. Though there is no universally accepted definition for crime, when I say what is crime, there is no definition which anybody has given, but any act which is opposing the peace and harmony of our nation, any act which is harming somebody in person, harming somebody's property, these kinds of acts constitute as crime. So basically I would say a crime is an unlawful act or omission which is an offense against the public and renders the person liable for legal punishment. And anybody who tries to commit that act which is prohibited by the law, So if these kinds of acts are committed by any person of our society, of our nation, they are liable for legal punishment, which is very well defined under the various acts which we will study further. Criminal law in India. There are three primary laws that deal with criminal matters in India. Now, how do I decide what punishment is to be given? How do I decide what activity is supposed to be crime and what activity is not supposed to be crime? So there are three major acts which primarily deal with all the criminal matters in our nation. First being the Indian Penal Code. You must all be a little aware of IPC. We have all heard it somewhere or the other. IPC is the Indian Penal Code. It is a substantive law and defines the acts which are crimes and punishment for such crimes. So in Indian Penal Code, there are the crimes have been defined and the punishment for these crimes have been defined. For example, if you commit a murder, for how long will you be sentenced in the jail, or you will be sentenced to death, or if there is attempt to murder, rape, so different crimes and their different punishments have been properly defined under the Indian Penal Code. Then we talk about CRPC, that is the Criminal Procedure Code. Now, as soon as I say Criminal Procedure Code, you understand there is something related to the procedure. Whereas IPC gave us the punishments, CRPC will give us the procedure in which how a particular crime is to be dealt. Okay, what procedure has to be followed in forms of investigation and in forms of prosecution. So Indian Penal Code is a substantive law. It gives us only the punishments. It tells us about the kind of punishment which is to be awarded, whereas the Criminal Procedure Code, it is a procedural law. It describes the procedure for the prosecution of crimes in forms of investigation and trial. Then third, we have the Indian Evidence Act. We all have heard that no crime can be proved or no person can be proved guilty without substantial evidence. So the third most important act to administer criminal law in our country is the Indian Evidence Act, which describes which material can be used as a evidence against the person who is to be proved guilty, or what evidence should be used for a person who needs to be proved innocent. So these are three primary and most important acts when we start talking about criminal law, which you should remember. First being IPC, which is the Indian Penal Code. Second being CRPC, that is the Criminal Procedure Code. And third is the Indian Evidence Act, which administers the evidences.